why should we be having these conversations? Why should people, instead of spending a night at a restaurant, at home, in front of a fire with their loved ones, why should they be sacrificing their time listening to us, kind of provoking them to have a conversation about competition law? What's the value?
It's a good question, and I think, competition law, out of all the regulations, almost looms large over the economy because it has an economic-wide effect. And I think there has been substantial debate in the last year or year and a half about the role of the competition authorities, with many critiques of what we're doing as the competition authority, but also many applauds for some of the things we've done in order to grow the economy, but also prompt a more competitive economy, reduce the cost of living. So I think it is important to have this debate, and I commend GIBS for having this forum, because it's useful to have these sort of discussions in a structured, mature manner than opinion pieces floating through the press, and to ensure that the different stakeholders come together, and also those stakeholders and ourselves don't end up in sort of groupthink mode and don't reflect on what we're doing, either as business, academia, or the Competition Commission.
Could you just give us like a tour de force about the competition law ecosystem? Who are the key players, what their different roles are, so that when people are having a conversation, they don't hold you accountable for something that happens, for example, at the tribunal, as opposed to something that happens at the Competition Commission.
Yeah, so you've just mentioned that there's two authorities. We decided to separate the Competition Commission, which you could say investigates, prosecutes cases.
So you guys are the scorpions, right?
We're the scorpions, exactly. Except not as sexy, and our dawn raids are more limited. But and then you've got the Competition Tribunal, which is separate and adjudicates, and that's to create the independence in the process. So most of our decisions, as we put it, are recommendations to the tribunal. We do make some decisions ourselves, but in terms of the big areas of competition law, merger control probably gets the biggest focus. There it is, firms merging with each other over a certain size have to notify, and we assess for competition, but also public interest. And the public interest aspects have a degree of critique and controversiality, but we'll get into that.
Yeah.
So that's been a big area and a big part of the debate about the role of the competition authority and investment. Are we too slow? Are we stopping deals? Are we stopping investment? So that's an important element to that. The other broadly, I would say, is anti-competitive conduct, which can include cartels and also abuse of dominance and market inquiries. And that is looking at conduct of firms in the market which might restrict competition in particular ways. A cartel obviously limits competition between its members, but a large firm can abuse their position by trying to exclude others from entering the market or expanding in the market. So those are your big sort of two areas, I would say, where we're active.
Is there a difference between looking after competition and looking after competitors?
Yeah, that is one of those long, big legal debates in the courts, and for some, yes, we're looking after competition, not particular competitors. But if you don't look after the competitors, you don't look after competition as well. And so there's an element of that. And if we had to sort of look at our toolkit, you could say, compared to other regulators, a lot of our work is ex post. So looking at conduct, is the conduct is happening, we're investigating and trying to stop it. Merger control is sort of ex ante, looking forward, trying to forecast what mergers might do to the market and might do to competition. It's a tricky exercise, but that is trying to preserve competition. The one area where South Africa has sort of moved forward is in market inquiries, where it is more trying to inject competition into a sector. We inherited a very concentrated economy, and so we're not in the same position as the US, which has a vast market and has 110 years of competition law. We're in a different situation. So much like a sector regulator, we might also try to inject competition to make markets work better, and that's a market inquiry.